My name's Adrian Marlowe. I'm CEO of the legal consultancy LawSpeed and chairman of the Association of Recruitment Consultancies. I and my team here have been working with recruitment businesses since 1997, and we've seen lots of things going on over that period. IR35, conduct regulations, agency worker regulations, changes to tax laws and so on and so forth. We've lived through these relatively turbulent times and watched the fantastic success of the recruitment industry. Now, every once in a while, something happens that is really worth talking about, something that really matters to the recruitment industry, and now is one of those times. On the 2nd of June, the government launched a consultation called, if I can just read this out, ending one-sided flexibility, reform of 0 hours and similar contracts. Now, this could have passed a lot of you by. There's no mention in there of any potential impact on recruitment businesses, but it follows the Employment Rights Act 2025, which introduced the concept of guaranteed hours. No mention in the name of guaranteed hours, but it is in fact, for your purposes, all about guaranteed hours. Now, what do I mean by guaranteed hours? The Employment Rights Act 2025 requires the government to introduce legislation effective in 2027 that requires hirers to offer direct jobs to candidates that you supply after a period of time called the reference period. That period of time in the consultation is preferred by the government to be 12 weeks. So from 12 weeks after the beginning of a supply, your hirer is going to have to offer that worker a direct job on the same terms that they were on before, that is the same hours, rate, and so on and so forth. And that would be a direct contract. So if you're supplying a candidate to the client will be effectively taking the candidate off your hands. That is the plan. Now, the period of 12 weeks is not set in stone at the moment, but it is definitely the government's preferred period of time. Clearly, that will impact on any longer term supply arrangement you may have with a client. It will impact in a number of ways, in fact, because the client probably wants a temp and doesn't want to have to offer a job to a direct worker. At the same time, some clients might use it to see an easy way into hiring permanently a worker that you've introduced for supply through the back door. In other words, without paying you any kind of transfer fee. Clearly, if the hirer has an obligation to offer the job to the candidate, then they're not going to want to pay you a transfer fee. Very, very simple. So if they want to get a permanent person in, one thing they could do is say that they want a temp, 3 months later take them on a direct contract, and in the meantime, because of the obligation to make the job offer, they refuse to provide you with any kind of transfer fee or won't agree those terms in your contract. So it's a pretty big issue. But there's another aspect which is not being talked about at the moment, and which I really want to draw to your attention right now, which is that if a hirer doesn't want to offer the job to your candidate, then the hirer could face an employment tribunal claim if they terminate the assignment before the 12-week point, which is, in my book, pretty horrendous. What it means is that if you supply a candidate to a hirer, the choice is removed from them completely. If they decide for even proper reasons that they want to terminate the assignment before the 12-week period is arisen, then they could face an employment tribunal regardless of the reasons. The fact is, they may well win the case if it goes to an employment tribunal if there is a proper reason. But the real impact is that they have the potential of facing an employment tribunal claim regardless. We all know, of course, that hirers use temp workers to help them grow, to help them build their businesses up in times of uncertainty, such as, for example, times like right now. So it seems to us that this is just going to be a drag on growth, it's going to be a drag on confidence, and in particular it's going to be a drag on the recruitment industry in terms of the value of the services that you provide when you're providing temp workers. Now, that value, if you can't get a transfer fee, has to translate somewhere else. It can only translate in the way you deploy your other charges. So I imagine if you expect to get a transfer fee of a certain amount for a particular type of candidate at a certain value, and you know you can't get that, you may be tempted to increase your margin to compensate for that. That, of course, will have the effect of pushing up costs to your hirer. That may make the idea of hiring an temp less attractive. That in turn could result in you not being able to supply that temp. And in any event, if the period is 12 weeks and you want to supply a temp to a hirer who needs somebody for 6 months, you can only really, with any certainty, pencil in a 3-month hiring. And that's regardless of what your candidate might say at the outset, because there is no obligation on the candidate to accept a job offer with the hirer direct, but there's always a risk that they may do. And you will have to factor that risk into your assessment of how you do a deal with your client. Now, all of this is new and going to affect supply recruitment, and as I've said, it's likely to also affect risk when it comes to making any kind of permanent placement. A client might choose to go down that route, take the supply for 3 months, offer the direct job, don't pay any transfer fee, and you lose your perm placement fee. That is one potential outcome of all of this. So why am I talking to you today? First of all, it's to alert you to this. Many times new legislation passes people by. They don't think it's serious, and so they don't take any action. But the reality is there is an open consultation that closes on the 25th of August. And what we are trying to do on behalf of our trade association members and our clients is to gather enough data to show that there will be a negative impact on industry, that is businesses generally and also recruitment businesses. If that is the case, if the data supports that this data needs to be collated and then put before government to deter the application of this proposed new legislation in 2027, or alternatively to massage it so there is a minimal impact on recruitment agencies and on businesses. So what can you do right now is I'd love to know from you what you think about this proposal. What do you think about this legislation, just as a general view? The second thing I'd like to know is what do you think about the 12-week period? It is up for grabs, but as I say, 12 weeks is the preferred period by government. It could be 6 months, it could be 12 months. Arguments need to be put forward to support the idea of a longer period, which clearly the government is not really in favour of, but nevertheless we can put arguments forward in relation to that. The third thing is, what do you think about hirers being put in this position? What do you think their reaction will be if they take on a temp and they have to offer a direct job to the worker? That's probably means it's a good idea to have a chat with some hirers and see what they think about that. Whether you feel able to do that or not without upsetting the hirer in any way or alerting them to a problem down the line is entirely up to you. But if you have a good relationship with the hirer, then it's probably a good idea to have a chat about the legislation as opposed to any way you might deal with it. Will it have an impact on flexibility or growth? I'd love to know what your views are around that also. So there we are, that's about it. That's my introduction to the guaranteed hours concept. I hope you understand it. If you've got any thoughts, post it up on the WhatsApp, or you can email to info@arc-org.net, which hopefully should appear on the screen now. And if you're able to provide me with any data showing the calculation of adjustments to your margin because you believe that your hirers will not agree transfer fees going forwards, that would be absolutely great to have. Okay, thank you very much, and I look forward to hearing from you.